Well, is it cheaper today because of the tariff decision?
Maybe cheaper tomorrow.
We're going to get to that. I was in Canada for a wedding recently, a few months ago, and I kept asking for getting some provisions for various folks, and there was no California Cabernet and there was no Texas vodka, so I had to leave the store. But that was all due to this the tariff war. So as you can see, it deeply affected me and my family personally.
You seem to be weathering the storm okay, though.
I think I'm doing all right. So we got folks streaming in at the end of the week. Steve, thanks for taking the time. Glad we have you. It's complicated for a lot of folks. Let's take it one step at a time. Remind folks in a sentence the basis on which Donald Trump and his administration claimed that they could impose these sweeping tariffs unilaterally based on their understanding of executive power without input or objection from the Congress.
Yeah. So the tariffs, what we might call the retaliatory tariffs, although there were also some fentanyl-based tariffs that were also in today's ruling, were based on a very muscular reading of a statute, specifically the International Emergency Economic Powers Act of 1977, which we lovingly call IEEPA.
IEEPA.
And, from your Justice Department days, IEEPA is a very powerful tool for the executive branch when it comes to various forms of international economic regulation, transactional investigations, et cetera. It had never been used for tariffs before. And in fact, there are a series of other statutes. Section 232 of the Trade Expansion Act is just one example where there's much more specific tariff authority. But those other statutes also have substantive and procedural constraints that IEEPA doesn't. So, the Trump administration tried to rely upon IEEPA for these tariffs, and it lost in the lowest court, the Court of International Trade. It lost in the Federal Circuit. And today, in a 6-3 ruling that has gotten already quite a lot of media attention, it lost in the Supreme Court.
You might say Donald Trump didn't have the cards. Is that one way to put it?
Didn't have the cards. You can have, there are so many metaphors you can do here, but I think I'll just stick with lost a big one.
So the split, it's complicated as people are making their way through the hundreds of pages of opinions. This is what a lot of people call a splintered opinion, because justices give reasons for why they believe in a particular decision and parts of a decision. And there are things, when we have more time in the coming weeks, we'll talk about the major questions doctrine and how some conservatives align with other conservatives on certain parts of the ruling. But in essence, as the reporting has suggested, it's a 6-3 decision on the principal point. The three liberals being in the majority with Roberts, Gorsuch, and Barrett. Do I have that right?
Exactly right. And, I think I'll just say, when coming out of the oral argument, I thought we were heading for 7-2 or 6-3.
Who was the seventh? Who was the seventh you thought we were going to get?
So I think the question was Kavanaugh. And I think that, he's perhaps the most interesting vote of the
right. Well, he wrote the dissent.
And he wrote what Justice Thomas called the principal dissent. And I know we'll come back to him. But yeah, I think so it's just to be a little legal nerdy for a second. Sometimes you have these rulings that are deeply fractured where there's no majority opinion at all. This isn't that. There actually was a decent chunk of Chief Justice Roberts' opinion that was joined in full by all 5 of the other justices. The real daylight between the 6 justices in the majority was all about the so-called major questions doctrine.
Yeah.
So they all agree that IEEPA doesn't authorize tariffs. They just disagree about exactly how they get there. And, those disagreements, I think, might matter in future cases. They didn't really matter today.
So talk about how this court, the majority of this court, found that President Trump, who we've talked about in this podcast and you've talked about in many places, including, I'm sure, in your classes, there's no executive authority or loophole through which he can argue executive authority that he doesn't seize. Again and again and again. And those are emergency powers that brought us Minneapolis. Those are emergency powers that brought us certain deportations. Those are, alleged emergency powers that brought us, troops and the National Guard. This is an extraordinary power that actually exists within IEEPA but simply not to the extent that the president demanded. My sort of larger question, we'll get back to the particulars of the case, is you and I and others have railed against the continuing encroachment upon all the other branches of this executive branch. Why here? Why put up the red light or the stop sign here? Does this tell us anything about where we're going overall or not?
So at the risk of, I think, disappointing some folks, I'm very wary about reading too much into this decision. I mean, I think it's a big deal on its own terms, Preet. It is. I mean, I realize this doesn't feel that way because of all the emergency applications that have come from the Trump administration. This is actually the first merits case of the second Trump administration. And, the fact that it was a big loss, I think is a pretty resounding signal, but it's a narrow signal. And so let me say a bit about why. So this is not a case where the Trump administration made any arguments about the president having inherent constitutional authority. Yeah. This is not a case in which the administration argued that statutes Congress had passed were somehow either not exhaustive or perhaps had even not fully occupied the field or might even be unconstitutional. They rested their whole case on what they thought was a better reading of the statute of IEEPA. And with this court, Preet, when you have what really is what we might call a pure statutory interpretation case, you're going to play into at least some alignments between some of the conservatives and the three Democratic appointees about how we do and don't understand delegations of authority to the executive branch. And I think that's why Adam Liptak in the New York Times said this was a declaration of independence by the Supreme Court.
You disagree. You disagree.
I feel like it's more like the Albany Plan of Union, right?
Who knows what that is, Steve?
The Albany Plan of Union, the first effort by Ben Franklin to create a charter of mutual cooperation among the colonies.
Right. It's like the League of Nations. It's like the League of Nations. Is that a better?
Not the UN. But let me say, but it's worth stressing why. I mean, so in the immigration context, the president is exercising powers both that he claims have been delegated by statute and in a field in which the courts have historically been more deferential to the president. Even if you think that the tariffs case is a sort of foreign affairs, national security case, and that's the Kavanaugh argument in his dissent, this is still not a topic on which the courts have historically bent over to the executive branch. Yeah. And so, I think this is a good sign that the court is not reflexively ruling for Trump in all of these cases. I don't know that we can say with any confidence that it's any kind of turning point, as opposed to just, a case that came to the court in a very different posture and on a very different question than all those previous emergency applications.
Let me just read a sentence from the Roberts decision, and you can maybe explain it to lay folks. Based on two words separated by 16 others in IEEPA, and those words are regulate and importation, the president asserts the independent power to impose tariffs on imports from any country of any product at any rate for any amount of time. Those words, Roberts said, cannot bear such weight. IEEPA, he points out, and this maybe is understandable to everyone, contains no reference to tariffs or duties, and until now, no president has read IEEPA to confer such power. Now, that last part, the fact that no president has read IEEPA to confer such power, substitute a different word for IEEPA, and you can have many, many examples of that. I don't know how much that mattered. But what did it matter that the president's team relied on those words and neither tariff nor duty appears in the statute? Isn't that sort of a slam dunk?
It should have been. I mean, I think this is why maybe you could have made the case that it should have been 9-0. Yeah. I think the federal circuit, the Court of Appeals that heard this case, when it sat on Bob Preet, it divided, I think it was either 7-4 or 8-4. And the dissenters actually, I think, had a decent argument, which is if you read statutes the way that I think we more often associate historically with liberal statutory interpretation, with sort of more purposivist interpretations, that there actually is not a ridiculous line of causation, line of logic from IEEPA's broad language to the president having broad flexibility in this space. The problem for the Trump administration all along, Preet, is that that's not how this court reads statutes anymore. And it hasn't been for the better part of 20 years. And so, if you hold up today's ruling, Preet, against the 2023 decision in the student loan debt forgiveness program case, Biden versus Nebraska, you'll find 6 of the justices in the same place. Right? So you'll find, the justices who think that the major questions doctrine denies the president this kind of power are the 3 Republican appointees in the majority. The justices who don't think the major questions doctrine should apply are the 3 Democratic appointees in the majority. And the only justices who are openly inconsistent on this are the dissenters, right? Kavanaugh, Thomas, and Alito. Yeah. So that's the argument for why this should have been an easy case.
In the real world, even though we're talking about law, there's a distinction that you have to make with students and sometimes in legal writing. Had it been the case that the tariffs were uniformly viewed by economists and experts as a good thing and proper and helpful, as opposed to universally panned as being idiotic and stupid and the product of tantrum, the legal arguments don't change, the words of the statute don't change, jurisprudence doesn't change, the state of play of the major questions doctrine doesn't change. Does the decision change?
Maybe. Maybe. Wait
a minute. You're a professor of law. You're saying that the law sometimes doesn't matter as much as other stuff?
I think that the reality is that the justices live in the world like the rest of us. And whether you take that as the cynical view, which is that the justices are worried about their own 401ks, or whether you take that as the more idealistic...
A couple of them are. I think a couple of them are. Yeah.
Or whether you take it as the more idealistic view, which is that the court is not supposed to be completely immune from and oblivious to public opinion. I think the reality is you end up in the same place, which is that the best chances the president's going to have for a, sort of deeply stretched, aggressive interpretation of a statute are going to be in cases in which that interpretation is broadly popular. We can talk about whether that ought to be how this works, but I think there's no denying that has been how this works. And so whether you view this as cynicism or just realism, you end up in much the same place.
Are you able to answer the question that some people might have, which is, Biden imposed tariffs, maybe not in the same manner, in the same degree, and on the same products. How come that was okay and this is not?
Yeah. So, presidents going back decades have imposed tariffs. But the difference, Preet, is that there are a handful of far more specific statutory authorities. And just to pick out one, something called Section 232 of the Trade Expansion Act of 1962, that presidents of both parties, including, we should say, President Trump during his first term, relied upon to impose tariffs, Preet, that were more subject matter specific. So, for example, the Canadian steel tariffs during President Trump's first term. That were more procedurally constrained. And I think the difference here is that President Trump couldn't use those more specific authorities to impose these broad, general, sweeping reciprocal tariffs. And, that doesn't mean that he won't come back tomorrow, Preet, with a new executive order imposing some subset of some of these tariffs under these other authorities. Yeah. But that distinction matters.
He certainly will he not? You are not the only observer of the oral argument who must have foresaw they could go this way. Do you have an understanding of how the president has been planning for this? I think even as we speak, I haven't caught the last couple of hours, but he's made some pronouncements on what he's going to do. How is that going to fare?
And he said some very nice things about the justices in the majority. It's hard to generalize, Preet, because I don't think there is any denying that some of these statutes, other than the one President Trump used for the reciprocal tariffs, do in fact provide tariff authority. Like no one is seriously saying it doesn't. And, insofar as there's any argument about what's called the non-delegation doctrine, that Congress couldn't delegate this kind of power to the president, really, I think only Justice Gorsuch is attracted to that argument. The hard question will be, what are these specific tariffs President Trump tries to impose in response? And are those based on, valid, plausible readings of the relevant statutes? And Preet, it's hard to generalize because we don't know what he'll do. My best guess, and this is really not, this is worth what everyone's paying for it, is that the president will do like something small and will claim it is much bigger than it is, and will claim that it is some massive repudiation of the Supreme Court, when maybe it's using sort of a very narrow tariff authority to put back some very small subset of what was already on the books.
Now, a question that lots of people are asking And this court seemed to avoid answering in any way, shape, or form. You're nodding your head. What about the tariffs that were paid, Steve?
Yep.
What happens to those? Do they get paid back? How does that work?
So let me start with we don't know. Let me sort of go from there. The folks who were surprised that the Supreme Court did not address this, I think, should not have been surprised. That this is a incredibly messy question. It's a question that no one in the lower courts had talked about at all. And I think that the justices are perfectly happy to let the lower courts, in this case, the Court of International Trade, go first. But there's a larger point here, Preet, which is this is not the first time in the Supreme Court's history that we've had a massive ruling that had immediate, significant economic effects. And in prior instances where this has happened, the court has operated sometimes informally and sometimes formally with an expectation that this other branch of government, we used to call it Congress, right, would actually step in and fill the gap. And, so a good example of this is in 1982, when the court invalidated the entire bankruptcy court system. The justices paused their ruling for long enough for Congress to fix it. If you go back a little further to the end of World War II, there were a series of rulings where the justices reinterpreted the Fair Labor Standards Act to impose a ton of retroactive liability on employers from World War II. And Congress responded by sort of apportioning out what would be and what would not be allowed to be collected. So in a system in which we had a function of separation of powers, this would actually be a policy question for Congress. I think neither you nor I are going to hold our breath that Congress is going to do anything here. And so I think it's going to go back to the lower courts where, it will be a mess, but I think that's a mess that was inevitable. And, I'll just say I would be surprised if at the end of the day, the result is everyone gets their money back. That seems to me to be the least likely outcome.
Just so I understand, reasonable and lawful and appropriate for the justices to punt on this question or not? And then related to that, depending on your answer, given what we said earlier about how the justices live in the real world, was punting on this evidence to the contrary, that they don't live in the real world?
Let me take the second question first. I don't think so because, look, it already took them, 3.5 months to get out these 160 pages. And it's hard to imagine that they would have been in any hurry to figure out the remedy question in a way that was going to slow down getting this ruling out and onto the books. Maybe they could have ordered re-argument on the remedy question. That is something that in history we've seen the court do. But again, this is not something that the lower courts have touched on at all. And, it's not just in these cases, Preet, but we have all these other lawsuits brought by companies like Costco, right, that I think are probably better vehicles for trying to figure that out. There's an administrative process through, I think it's CBP, Customs and Border Protection, right, for folks to actually try to reclaim the funds. And so I think it would have been a very aggressive move by this court to try to suss out all of those questions when they hadn't been briefed and argued in the merits part of this case.
Now, a lot of business people, I have clients my law firm has lots of business clients who want some repose, some closure, some predictability. They're just not going to get it. Ain't happening, right?
I would think we are not getting immediate closure in any way, shape, or form. What happens in the lower courts, I think, is an open question. I think there are different ways that the remedies issue can go. I think there will be some jostling for which court or courts will decide this question, right? So, the case the Supreme Court decided today came out of the Court of International Trade. It's possible that some of these other lawsuits will be brought in the Court of Federal Claims. And so, the short answer is yes, this is going to be a litigation program in the short term for, your firm and lots of other law firms. I think we should, though, not lose sight of two broader points. The first is, again, this is exactly the type of mess that historically we actually would have looked to Congress to try to fix. And the fact that we're going to be stuck with the lower courts is yet another, I think, indictment of Congress's fecklessness. But second, from the court's perspective, I don't think that if you're John Roberts and you're thinking about the institutional relationship between the Supreme Court and the other branches, the question of whether individual businesses will be made whole is one that you're losing sleep over, even if you and I might think it should be.
Yeah. As you alluded to, the art is formerly known as Congress. But on the question of certainty and what is to come in the future, is it the case that notwithstanding these other authorities the president may have, some of which are temporary, tariffs that can be put in place for a limited period of days, I think one of them is 150 days, that if you're a manufacturing concern in another country, you can be pretty sure that you will not have a wackadoodle 50, 80, 100% tariff placed upon your products going forward in any way, shape, or form, correct?
I guess what I would say is I have a very hard time, if I were giving advice right now, telling anyone to be confident about the predictability of what this administration will or will not do. And so...
Well, wait, I'm sorry. What's the basis on which, I don't know enough about trade law, what's the basis on which Trump could reinstate to the same extent and on the same scale the tariffs that he has in place now?
So I don't think he can, but I also don't think that we can be confident that he won't try to stretch the other statutes.
Right. Yeah, the 14th Amendment, perhaps.
No, I mean, but realistically, I mean, like this administration.
Yeah.
So
So
President
then that
Biden
will have to be litigated itself again.
And let me just say, I mean, President Biden got a lot of grief from the right, for trying to do student loan debt forgiveness through a different statutory pathway.
Yeah.
Once the Supreme Court closed off the first one.
Yeah.
I don't, as long as it's a viable application of the statute, I don't think it's necessarily lawless. But I think the real point here is that this administration is not, I think, predictable in ways that its predecessors were, sufficient for small businesses, whether inside or outside the United States, to actually rely heavily on what they think is going to happen next.
Is there anything about this decision in the 6-3 that would cause you to call this, as we sometimes say, a case of strange bedfellows, or does it make logical sense given where those justices are, and it was a matter of statutory interpretation as opposed to constitutional interpretation?
To me, it is. I am more surprised that Kavanaugh's in the dissent than I am that Gorsuch is in the majority. Justice Gorsuch, I think, has been very aggressive in ruling for the Trump administration on a bunch of these emergency applications. So he's, we've seen him with Gorsuch, with Thomas and Alito in, a lot of those cases. But this is just a pure statutory interpretation case that checks all of his boxes. And, I guess to me, it is much, much more. I walked out of the oral argument in November thinking it would be 7-2. And, I was wrong about Kavanaugh, not Gorsuch. And I suspect that there are other folks who probably feel the same way. The strange bedfellow here is that it's Kavanaugh with Thomas and Alito, not Gorsuch.
So on Thomas and Alito, did they rule predictably the way they did in favor of presidential power because they love them some presidential power? And it just so happens that their interpretation of the statutes jibe with their endearing feelings towards executive power, or is it something different?
I would love to be able to say that they've been consistent about executive power in this space, but just to go back to the student loan case one more time, it is really hard to put their votes in that case next to their votes in this case. And the same is true, frankly, Preet, of Justice Kavanaugh. And, Kavanaugh's dissent, his 63-page dissent, makes much out of this being a foreign affairs / national security case. But, folks might not remember that in the student loan case, the statute on which the Secretary of Education was relying was a post 9/11 emergency statute. It was power that Congress delegated in a national emergency. And indeed, that the student loan debt forgiveness program was specifically about the COVID emergency. And so you might think those are factually distinguishable. It's really hard to see how you have one theory of statutory delegation in that case and a different one in this case.
Yeah. We got to get going. People have happy hours to attend. Steve, but I have a final question. I have heard some rumors and some speculation that one of the justices about whom we've been speaking and you have a lot of sources everywhere in the world. I've come to learn. Sam Alito going to retire in June?
So let me say I have absolutely no inside information to answer that question. But that won't stop
you
me
guys
from
don't have
speculating.
dinner? You guys don't have dinner from time to time?
You know, he's a Phillies fan. I'm a Mets fan. It's just it was never going to work out.
But what do you think?
I think that if you're looking for clues, the clues are leaning toward, and I see three in particular, Preet. So the first is he has a book coming out in October. And you know, the justices have, I mean, 7 of the justices have now written books. That's not new. But releasing a book in October is a very interesting move, since that's usually the busiest,
Right.
or at least the second busiest time of the Supreme Court's term. Very hard, Preet, to do a book tour when you're sitting on the bench. So that's clue number 1.
That's a good clue. That's a good clue.
Yeah. Clue number 2 is there's a very hagiographic biography of him coming out from Molly Hemingway, which I think is also a sort of a denouement type piece, if you will.
Swan song, yeah.
Exactly so. And I think clue number 3 is, frankly, the shifting political tides. You know, I think 4, 5, 6 months ago, you and I probably both would have said the chances of the Democrats retaking the Senate in November were still quite low. And I think that math has changed. Not to the point where anyone can be confident, but that probably includes Alito. And so, you know, I don't think there's a universe in which he would ever consider retiring in the face of a Democratic Senate.
Those are very good clues, Steve. You know, at this point of personal history, when I worked in the Senate Judiciary Committee, I worked on the confirmation hearing of Sam Alito, for whom that took place in January of 2000, I think January 2006.
Yep.
And I started working in the Senate in 2005. And now we're talking about his retirement. So the reaction I have most personally is that, wow, I'm old. And time flies. And we'll see what it means for the Senate, for the court, and for the nation.
Preet, that was my first year teaching.
Was it?
0506. And so
I imagine we must have talked back then, because I was talking to a lot of constitutional law professors to understand what the important issues were for the hearings. And so he's been on the court a long time.
But imagine you're a baby law professor and your first couple months on the job, Chief Justice Rehnquist dies. Right. Justice Roberts is confirmed to his seat. O'Connor resigns. Harriet Miers' nomination is killed.
2.5 nominations, I always say.
Yep.
Your students probably don't remember who Harriet Miers is.
Nope. But it's a remarkable marker, Preet, of how much the court has changed in really what, by historical terms, is a very short period of time. You might remember Justice Breyer in 2007, in his oral dissent from the bench in the parents involved case, says, seldom in the law have so few changed so much so quickly. And I feel like, that was, that was nothing compared to what happened since.
Query how Antonin Scalia would do at a confirmation hearing today. And relatedly, as I've heard some people mention recently, imagine this, that Ronald Reagan would have a very difficult time winning the Republican primary. That's how far we've come. All right, folks, drink them if you got them. Have a great weekend. Steve, I have a Diet Coke. I gotta upgrade.
No, mine just Spindrift. So I'm.
Oh, I didn't see that. Okay.
Yeah.
All right. I thought it was just.
I wish
turpentine or something. All right, Steve.
Thanks everybody for joining us.
Thanks for joining us on a Friday evening. Very important stuff. Thanks so much. Bye.
Great to see you.